Imagine you've just been let down by a contractor. They took your money and walked away. You want justice, but what exactly can a court give you? In contract law, the answer depends on which remedy you're pursuing and why. Contract remedies fall into two broad camps: common law remedies, primarily damages, which compensate the claimant financially, and equitable remedies, which can compel or restrain conduct. We will work through each in turn. The primary remedy in contract law is expectation damages. The goal, as stated in Robinson v. Harmon in 1848, is to place the claimant in the position they would have been in had the contract been performed. This is sometimes called the benefit of the bargain measure. You're not just recovering what you spent, you're recovering what you expected to gain. So if you contracted to buy goods at £10,000 that were worth £15,000 and the seller pulled out, your expectation loss is £5,000, the profit you would have made. Damages are assessed at the date of breach, though courts have some flexibility where that would produce an unjust result. Sometimes expectation loss is too difficult or speculative to quantify. In those cases, a claimant may instead claim reliance damages, recovering wasted expenditure incurred in anticipation of the contract being performed. The key authority is Anglia Television v. Reed from 1972, where the Court of Appeal allowed the claimant to recover pre-contractual expenditure that was wasted when the defendant actor walked out. Crucially, reliance and expectation damages are alternatives. You cannot claim both, and if the defendant can show the venture would have made a loss, reliance damages may be reduced accordingly. A claimant cannot simply sit back and let their losses pile up. They are under a duty to take reasonable steps to mitigate their loss. Brace v. Calder in 1895 is an early illustration. The claimant failed to take reasonable steps to minimize loss, and recovery was reduced as a result. Alongside mitigation, the rules on remoteness also limit recovery. Under Hadley v. Baxendale, decided in 1854, a defendant is only liable for losses that arise naturally from the breach, or that were in the reasonable contemplation of both parties at the time of contracting. Losses that are too remote are simply not recoverable, however real they may be. Specific performance is an equitable remedy that orders a party to actually perform their contractual obligations. Because it is equitable, it is discretionary. Courts will not award it automatically. It is unavailable for contracts of personal service, and courts will refuse it where compliance would be impractical or disproportionate. In Cooperative Insurance Society v. Argyle Stores in 1997, the House of Lords refused to order a supermarket to keep trading, on the basis that supervising ongoing performance would be unworkable. Specific performance is therefore most naturally suited to contracts for the sale of land or unique goods, where damages would be an inadequate substitute. An injunction is another equitable remedy. In the contractual context, a prohibitory injunction can be used to restrain a party from doing something that would breach a negative stipulation in the contract. The classic case is Warner Bros. Pictures' Voight Nelson in 1937, where Bette Davis, an actress, was restrained by injunction from working for another studio in breach of her contract, even though specific performance of the positive obligation to act for Warner Bros. Could not be ordered. Because it is equitable, an injunction is subject to judicial discretion, and the court will weigh the balance of convenience and whether damages would be an adequate remedy. Restitution operates on a different logic entirely. It does not seek to compensate the claimant for loss, but to reverse the unjust enrichment of the defendant. The most important contractual context is a total failure of consideration, where the claimant has paid money but received absolutely nothing in return under the contract. In Fibrosa Spolka Aktina v. Fee Farben Lawson from 1943, the House of Lords held that money paid under a contract could be recovered where there had been a total failure of consideration. The action is essentially for money had and received. Note that restitution is separate from damages. The claimant is not recovering expectation or reliance loss, but unwinding the transaction. Here is a scenario. Priya pays £5,000 upfront for a bespoke software system. The developer never delivers a single line of code. Which remedy best recovers Priya's £5,000? Option A, expectation damages for the profit she would have made using the software. Option B, restitution, recovering the £5,000 on a total failure of consideration. Option C, specific performance, forcing the developer to build the software. Option D, Reliance Damages for her pre-contractual advertising spend. The answer is B, restitution. Because the developer delivered absolutely nothing, there is a total failure of consideration. Priya can recover the £5,000 she paid to reverse the unjust enrichment following the principle in fibrosa. Contract remedies range from expectation and reliance damages at common law, subject to mitigation and remoteness, to equitable remedies like specific performance and injunctions, through to restitutionary recovery where consideration has wholly failed. The right remedy depends on what the claimant has lost and what the court considers just. Your modules, mapped to your uni. Explainer videos for every topic. A tutor that knows your course. Essay writer for your essays and graded. Case briefs, flashcards, annotations. Try it free for 7 days. Link in the description.